Hello and welcome to SciLux, the podcast where we talk about scientific developments and technological changes in Luxembourg, sometimes also in Europe, but today it's Luxembourg, which means we are proudly powered by Research Luxembourg and recording at the Media Center of the University of Luxembourg. And our guest today is Professor Takis Tridimas, the founding director of the Luxembourg Centre for European Law at the University of Luxembourg. Professor Tridimas is the author of The General Principles of EU Law, one of the most frequently quoted books by advocates general of the European Court of Justice. He has also prepared the latest edition of the Foundations of European Union Law, originally edited by Professor Hatley, and this of course means we will be talking about European Union law today. Professor Tridimas, thank you so much for coming today.
Thank you very much. It's my pleasure.
All right, so we are talking around the Europe Day, of course recording before, but it will go live around the Europe Day, which means I wanted to start with a question I did not share with you, but you already know I don't always share all the questions. What is Europe for you, actually?
Europe for me is a set of values. It's about democracy. It's about putting the citizen at the center of society. Europe to me is about a single community where people can share ideas, they can travel freely, and they can use their collective efforts and wisdom for more peace, more prosperity.
So we are talking European Union then?
We are talking European Union, but I think the ideals are wider really. I don't think that anybody owns the values of democracy, the values of human rights. I think that they are universal. So I study them in a particular context, which is the European Union, but I don't think the European Union owns these values.
It's true. I really like that definition, and also makes me think that we are not always aligned nowadays with that, are we? Looking at some of the countries, some of them kind of go away, then they come back, and some are pretty distant from those values, although members of the European Union.
I think that is correct. I suppose there are two things here. One is that one must always strive to achieve these ideals. I think it is very much a constant effort. And the other thing is that we need to be aware that things can regress. I think we tend to forget if we have peace for many years or prosperity for many years or democracy for many years, we tend to take it for granted, but it isn't quite like that. I think historical experience suggests that all these things can regress. So I think it is important to be aware of the past. I think it's important to be aware that if we have certain values, it is not because they exist, it is because we make an effort to obtain them and to retain them.
When we talk about values, we also talk about rights and fundamental rights as such, right? Would you agree that ECJ that we'll be talking about, so the European Court of Justice, is basically guarding those fundamental rights? That's one of the roles of it?
Correct. It is one of the courts that protects the citizen. It is by no means the only one, but I think you're absolutely right. I think it has done a lot to protect the citizen throughout the European Union. And in my view, we are all better for it.
It has done a lot. Of course, this is opinion and not a very vetted scientific paper that we're talking about here. But is it enough? Once in a while we sit down and we talk, okay, yes, there are those institutions, but are they really powerful?
Well, that's interesting. I think as society changes, technology changes, there are new challenges, there are new opportunities, there are new problems. And therefore, citizens may have different expectations from the ones that they had in previous eras. I think there may be new threats to their protection. The digital revolution, for example, the public space that online platforms have create enormous opportunities, but also pose their own threats. And the law needs to adjust accordingly. We have all sorts of new rights, I would say. The sustainability, the environment, nature, all these concerns have come, and rightly so, to prominence in fairly recent years. And there is a host of rights that goes with them, or that should go with them. Animal rights is another area. People didn't tend to think in terms of them. I think as society changes, so do expectations, and these need to be managed. It doesn't mean that all these expectations should translate into rights.
It is very true, but then again, as we're talking EU law, isn't 80% of what you mentioned more national jurisdiction than actually something that should be discussed on the EU level?
That's interesting. Not necessarily. I think that the story of European integration, I think, is a story of empowerment. We started with 6 countries in the 1950s. Since then, the European Community Treaties and now the European Union Treaty have been changed a number of times. They have been amended a number of times. And there are essentially 2 kinds of revisions. One is to expand the European Union. We started with 6 member states. We now have 27. It remains a very popular club despite Brexit. And we also have a long line of countries that wish to join. So first, the story of European integration has been a story of expansion. And secondly, it has been a story of deepening. The revisions that have been made to the European Union treaties have tended to increase the powers of the European Union, to increase the competence of the European institutions, the areas in which they can legislate, and also to make the whole process more, I would, with some reticence, use the term federal. They've made the whole process more federal in the sense that a lot of decisions are taken by the majority of member states. They don't need unanimity. So the story of the EU has been a story of both widening and deepening the integration and therefore giving to the European Union power over many areas of law. So many of the areas that I covered are actually, I would say all of them, are of concern to the European Union.
So looking at it from a citizen perspective, because I kind of made you talk more general, now let's get more specific. So if I am interested, let's say I feel that some of my rights or some of the situations that I'm dealing with right now might be a case for the ECJ or in general the EU law, what could they be? Let us just be very specific right now. What does EU law cover?
Among the areas that it covers are the following: commercial rights, rights of free movement, how a corporation can move from one member state to another and take advantage of the market there. So there is something very, if you wish, very liberal, very capitalist, if I can say so, about the European Union. But also this goes hand in hand with what we call social Europe. The European Union has increased the protection for workers. It has done a lot to facilitate non-discrimination. If you ask me what has been the greatest achievement of the European Union so far, I would probably say not the free movement as much as gender equality. It has really transformed the laws of the member states in relation to the equality of the sexes since the early 1970s.
So these are just 2 examples, of course, listeners, right? Not everything, but just some examples. And what about then the role of ECJ in this? Can I just go there as a private individual with my complaint, let's say?
It is not quite as straightforward as that. Law is about formality, it's about process, and there are 2 ways of reaching the European Court of Justice. One, and the main one for the individual, is via national courts. In other words, an individual, a citizen or a corporation can claim a right given to them by European Union law, but usually the first port of call would be the national court. You go to your local court and you say, I have a right, but this right is not given to me actually by my national government. It is given to me by the EU. And then the national court will ask the European, if the national court thinks that there is something in my claim, and if it thinks that the answer is not obvious, then it will refer the case to the European Court of Justice. So there is indirect access. And that has advantages and disadvantages. The advantage is that every court in the European Union essentially is an EU court, automatically becomes a forum for the assertion of EU rights. And I think that gives to European Union law a kind of immediacy that only national legal systems have. So I can live in the north of Finland, in Lapland, and I don't need to go all the way to Luxembourg. I just go to my local court, or I can live in a Greek island, and I just go to my local court and I say, I have a right. I, as a female employee, I need to be treated in the same way as male employees in my position are treated. And I want my national court to enforce that right. And the national court If the right is obvious, the national court can do it itself, or if it thinks I clearly don't have a claim, it will reject my action. But if there is a genuine doubt as to the limits of the right, then it will take the case to the European Court of Justice. So that is an indirect way of reaching it. And as I said, for the citizen, this is the main way of doing so. There is also a more direct way of going to the Court of Justice, where an individual goes there directly, but that is more difficult. The individual will go there to challenge a decision taken by the European Union, which somehow the individual thinks that affects their interests. And that, in really the overwhelming majority of cases, would be corporations. So the European Union, for example, has a very strong antitrust law, and it may decide that Microsoft or Apple violate competition law. It may impose fines on them. So they can go directly to the Court of Justice to challenge those fines. Or individuals can also go to the court to claim damages against the European Union. It's not easy, but it is possible. So there are two ways of going there. One is via the national court, which is the most common, and going to the Court of Justice directly, which for the individuals is less easy. For governments, it's much easier. Governments can also challenge EU action before the Court of Justice.
So for the most common way, as you said, would you agree that it's a little bit like role of a constitutional court?
I think that's correct. It is not formally a constitutional court, but I think it does have all the attributes of it. So what is a constitutional court? What in substance? Well, in formal law, a constitutional court is one which has constitutional in its title. But in substance, what is a constitutional court? I think is one which decides on the relations between the citizen and the state. It upholds, in other words, fundamental rights, and one which decides how a society is governed. A court, in other words, which hears disputes concerning the allocation of powers between different institutions of government. And certainly the European Court of Justice does both those things. It decides whether the member states or the European Union has competence, has power in a particular area. It decides whether individuals have a specific right.
And it also reminds me, as I'm originally Polish, I had this feeling that in some way citizens realize how important constitutional courts are when they stop working the way they should, right? And I feel that in a way ECJ is doing a lot of work that we don't realize, but the moment it is actually in danger, we would actually realize how important it is.
I think that's right. To me, the idea of democracy, it has a number of components. The first one is, of course, majoritarianism. As a society, we think that the best way of taking decisions is by majority, through representative democracy. Direct democracy is not really feasible nowadays. So majoritarianism is very important. But I think democracy is more than that. It is also a set of fundamental values, a set of fundamental rights, which are beyond majoritarianism. In other words, you can't change them. You can't. The prohibition of torture, for example, is a value, is a right, and it is not really for the majority of the people to decide whether someone should be tortured. The same with equality. Equality irrespective of race, irrespective of ethnicity, irrespective of gender. And if you have this set of rights, then you also need someone to oversee them, to monitor them. So democracy and rule of law, the idea that everybody is bound by the law, also entails an institutional setup. There has to be an independent branch of government, i.e. the courts, with jurisdiction, with responsibility to ensure that the other branches of government, and indeed individuals, do not overstep their powers. So judicial independence and access to justice are essentially the entry points for the assertion of rights and absolutely pivotal to a democratic regime.
We're touching a lot upon rights. So then I start thinking of human rights as well. But we have a separate court of human rights. So what's the role then of ECJ? We're not talking about human rights when we're talking about ECJ, are we?
You're right. We have a separate court, and that is the European Court of Human Rights, which is administered by the Council of Europe, which is based in Strasbourg. Both the European Union and the Council of Europe are post-war children, as it were. They were part of the institutions that were established after the Second World War to enable Europe to recover, to enable European citizens to achieve their aspirations, essentially peace and prosperity. And the two courts are different. The European Court of Human Rights in Strasbourg is different from the European Court of Justice in the following respects. First of all, it has a much wider constituency. It is not only for the member states of the European Union, but many more states. Secondly, it only decides on human rights, on whether a contracting party to the convention has violated the convention rights. And thirdly, it is different in that it is a court of subsidiary jurisdiction. What I mean by this is that someone must have exhausted all the local remedies, must have gone to the national court, exhausted any means of redress available under the national legal system. And if that person still feels aggrieved, then it can go to Strasbourg. The European Court of Justice is a court that has jurisdiction on all matters of EU law, like competition law that I mentioned earlier, environmental law, consumer law, but also has jurisdiction over EU fundamental rights, a set of rights which are provided in the EU Charter of Fundamental Rights, and these are to a good extent similar to those of the European Convention. And the Charter says that the European Convention provides a floor but not a ceiling. In other words, the EU is committed to respect as a minimum the Convention rights, but it can provide higher protection.
Okay, going back to ECJ as such, because we talked about its role and kind of set it more within the European Union context, but we don't know exactly about the composition. So one of the things that you prepared for our listeners today is the pub quiz question about the composition of the ECJ. So if you can ask the question, and listeners, of course, remember, answer only at the end.
How many judges do you think the European Court of Justice has?
So we're talking a number this time, not, definitions as such. And remember, answer only at the end of the podcast. Okay, we're leaving ECJ a little bit aside. We might be going back now on the research side. Because, when I prepare for the podcast, of course, I try to read some publication. I could not read all your books, of course, unfortunately, to prepare. I don't have enough time. But I read some articles and some discussions, watched some videos as well of your lectures. And I still have sometimes problems with understanding what a researcher in law does. So what is research in law? What do you do as a professor of law? I understand you, of course, teach it, but what the research side looks like?
Yes, that's a fair question. I mean, let me first say that in general, I think that the role of an academic is the following. I would identify four roles really for an academic. I think we are there to impart knowledge, to teach. We are there to research, to always search for new frontiers in our subject matter. We are there because also we need to offer some citizenship to the university. Universities are big institutions. They have the various needs. And to facilitate teaching and research, there has to be an infrastructure. So we all have to contribute to that, or offer service to the university. And the fourth role, I would say, is serve the community, serve its academic in their own field of expertise, but engage with issues which are relevant to contemporary society and try and contribute. Now, what is research in law? It can be many things. It can be a very doctrinal, dogmatic research, which would entail, for example, studying a constitution, studying a law, a statute, studying the judgments of courts, and trying to make sense of them, trying to systematize them, trying to understand exactly what the courts say, identify problems, see how the extent to which they fulfill or fail to fulfill their objectives. And that is, I would say, traditional, classical, very valuable legal research. The other kind of research is looking perhaps more contextually at the law, trying to identify, for example, the political background to lawmaking, try to offer explanations why judges decide one or another way, explanations that go beyond the strict interpretation of the law, looking, for example, at subconscious bias in decision making. This may entail all sorts of different research, interviewing judges, for example, or interviewing lawmakers, members of parliament, interviewing civil servants. The role of a researcher really is to rationalize and to question. The trouble is the political process that leads to lawmaking is not really necessarily rational. It depends on all sorts of different things. The vicissitudes of the political game, the priorities, personal interests of specific constituencies. Law in the lecture room is very different from law in the parliamentary chamber, or for that matter in the court chamber. And I think academics can offer, by standing back, looking at the development of the law, can play a very important role, for example, in bettering argumentation, in law reform, making law reform proposals. There are some areas, for example, how technology affects legal relations. This is very topical subject, extremely interesting. Academics have this possibility to reflect. It's busy practitioners cannot do that. Judges don't have the time to do that. They have the possibility to compare different legal systems and draw synergies, borrow ideas. So, to my mind, legal research can contribute to political governance, to the way we're governed as a society.
And how do you get through to the decision makers then? Because, of course, there's always that difficulty of doing research, publishing, but that does not mean that then someone who will be actually taking the decision concerning a certain law change will read what you've done. So what is your approach to this? How do you reach the other side? Let's put it like that.
Interesting. I think, yes. Traditionally, universities, especially in continental Europe, are not particularly good at having the message delivered. In the United States, they have traditionally been better at it. But there are channels of communication. There are opportunities to do it by organizing workshops, organizing conferences at the Luxembourg Centre of European Law. One of our main missions is to do precisely that, bring together different constituencies with a view to exchanging ideas. We do it in the form of huge conferences, but we also do it in the form of smaller workshops where people can perhaps feel more free to express their views and their ideas, share their concerns. So being close to your audience, I think that is very important. I think that the decision makers are interested in academic research because it may help them in what they do. So I think they do read. Certainly, the European institutions do have open channels of communication with academia. And some lawyers also, some academic lawyers, practice law. And I think that is another way of reaching the decision makers. I have handled many cases at the European Court of Justice and the national courts. By necessity, one can only do that in the highest courts, because this is where the issues are issues of law. They're not issues of facts. These are sorted out at an earlier stage in the procedure. And I think that's also a way of gaining a better understanding of how the legal system actually works in practice, reaching perhaps an audience that one cannot reach simply by researching and lecturing, and bringing the different communities together.
And we have to mention here as well what is happening in Luxembourg. As you might be aware, the Luxembourgish parliament since a few years has the so-called cellule scientifique. That is exactly this bridge between the scientists and the deputies. And there are also some conferences organized. These are small steps, of course. We're just starting, but for sure there'll be more. So listeners, if you're interested into that, I will also share some information in the show notes. But it's great to hear that it's ongoing process. And I guess you're successful in that, because if the Advocates General quote your book so much, it means that you're getting into them with your research.
It also has to do with legal tradition. In continental Europe, there is a tradition of quoting academics. And so there is actually in the United States, in England, that I think judges generally have been more reticent to quote academic texts. But this has also changed over the last 20 years. We see more references to academic papers and to scholarship in judgments. And that's also partly because lawyers follow it, and therefore lawyers quote academics in the proceedings. So the court has to take on the argument, has to address those arguments. I think that when it comes to international law and European Union law, academics play perhaps a distinct role precisely because these are legal systems which are less developed than national legal systems, where the sources of law, I would say, are more diffuse, and therefore academics can have a greater input.
Is it why you started to specialize in EU law? Because you felt you can have a greater input. What's the reason? How do you start doing EU law?
I'm afraid, no, it is not. I would probably disappoint the listeners here. I did my studies in Greece, and the career path for a Greek lawyer is to go to Germany, because Greek law is based on German law. So I wanted to do something different, and I went to England to study common law, which is very different from civil law. And really, I began as a commercial lawyer. So I specialized in commercial transactions, financial regulation. And then by a complete accident, I found a job in a British university teaching commercial law. But the dean there thought that we should also be teaching European community law then. That was late 1980s, when it was a growing subject. And he said to me, "Oh, you come from Greece, you must know all about European Union law. Why don't you teach it?" So that's how I ended up. And I got very, very interested in it. So I tried to follow in parallel my interest in EU law and also my interest in banking and financial regulation. To start with, they were very separate areas, and one thought that they would never meet. But of course, they did meet with the financial crisis. And a lot of financial regulation is now colonized by European Union law.
That's why you also look into the evolution of financial regulation post-Brexit, I guess, because it also meets a little bit.
Correct. Yes, I have looked at that. Brexit has obviously been a turning point in the development in the evolution of the European Union. And it's one of those situations when nobody wins. Everybody is really worse off, apart from very specific, I think, groups which either because they championed the idea of Brexit or because they gained windfall benefits. But apart from that, it was a development which I think it was bad for the United Kingdom, bad for Europe. It shattered the irreversibility outlook of the European narrative, the idea that we will only be progressing, the idea that we will only be getting into a closer union. Because, of course, Brexit was the first time when a member state, and especially such an important one, decided to withdraw.
Maybe we don't go there that far, because we probably would need another 30 minutes to discuss this. But what I wanted to finish off with, I don't know whether this is going to be positive or not, but to look a little bit into the future, of course, right? So I know that, as I said, now I understand why there's the financial regulation in your research as well. But you, of course, look at the role of courts, right, and the balance between national courts, EU law and all that. But you also, I noticed, at least some articles said so, that you look at the EU's response to geopolitical changes. So how is the EU doing? Are we great? I know this is a very journalist question. You will not say yes or no here.
What the European Union is really is an organization which sovereign countries have voluntarily created because they think it is better for them to do certain things collectively than to do them individually. So it's I take a very functional approach. There is no grand plan of European integration. I think it is incorrect to think that somehow there is either a hidden or an open agenda about creating a superstate. That simply doesn't exist, because the different member states have different expectations from the European Union and different ideas. What they are all committed to is a process on how to decide. They have a commitment to institutions like the European Court of Justice. So how the EU evolves, I think it's very difficult to predict, because it depends on the vicissitudes of the political game. Who could have predicted COVID? Who could have predicted the financial crisis? Or who could have predicted the divergence between the United States policies and the European policies which we are currently experiencing? But because the EU is such an important player in economic affairs, it has to deal with geopolitical challenges, and it does its best. The difficulty, of course, is that the EU has power in the field of international trade, but it is very difficult to separate international trade from matters such as foreign policy or security concerns. So it is called upon to play a role, and member states try to hammer out common positions, common policies as much as they can. Here, the existence of institutions and processes helps, because if you have to follow an institutional process, if you do have an institutional setup, that might facilitate agreement, which would not be possible in the absence of it.
So does it mean we can be a stronger player on the global scene? Or that's basically we've reached the ceiling of the situation?
No, I don't think Europe has reached the ceiling. I think it can have a stronger voice, but that requires a political commitment, and it requires a heightened sense of solidarity, that it's the swim or sink together philosophy, which grants legitimacy to common solutions, even if those common solutions sometimes appear to be to the temporary disadvantage of one or another state.
Okay, so we leave it there. We'll see what's going to happen. Maybe we'll meet next time in a couple of years. We can discuss and comment on the developments, because as we said, we did not predict many of them, so we can't really now become a fortune teller or whatever else. But what we have to do is for sure solve the pub quiz question, because that's what listeners are waiting for. And I also had a few questions about that. So if you can remind us what the question was and then give us the answer.
Okay, the question was, how many judges are there at the European Court of Justice? And the answer to that is 27, because each member state has a judge. Of course, in law, nothing is easy. So things are a bit more complicated in the sense that the European Court of Justice has two kinds of members. They have judges, but also they have advocates general. So that increases the overall number of its members, not of its judges, but of its members. And things, again, because in law we like to make things as difficult as possible. When we say European Court of Justice, the term can mean two things. It can mean the European Court of Justice, which is the highest court of the EU, but it can also mean the institution, what we call the Court of Justice of the European Union, that has two courts, the General Court, which is the lower court, and the European Court of Justice. But the short answer is that the European Court of Justice has 27 members, because every country has a judge in it.
This is a great mention, because in general in the European institution sphere there is a problem of naming and confusion, right? As we mentioned, this is not EU institution but the Council of Europe, and then the European Council. That's already complicated. Then that naming here, as you've mentioned as well, we have different courts under one court. So good you said that. But then how many advocates general actually?
There are 11 advocates general.
So not every country gets one.
Not every country gets one, which then leads to delicate issues of how it is decided. There are some countries that have a permanent advocate general. The rest of the positions rotate among smaller countries. But I think what is important to bear in mind is that the people who are appointed there do not represent the national interests. So the Polish Advocate General does not represent the interests of the Polish government, or the French Advocate General does not side with the French government. The idea is that these are people whose independence is and integrity is beyond doubt, and who have proven expertise and good judgment.
So does it mean that if there is a case, from Greek government, the Greek judge will not treat it, or will it?
Correct. Correct. It is, yes, you're right in that. What is very important in relation to judicial independence is not only to make sure that the members of a court are independent, but also to give the appearance that they are independent. Because if people don't have this kind of confidence, then I think the courts would lose legitimacy. So there are rules at the court which make sure that if the French government, for example, brings an action against the European Union, the French judge will not be the juge rapporteur, the judge responsible for the case, and the French Advocate General will not be allocated the case. Now, it may be that the French judge will be part of the composition of the court that decides, but that is in no way against judicial independence. I would say quite the contrary. You need someone who knows also the national legal system, who can understand the nuances of it, and who can help the court come to the best solution.
Of course. So I hope, listeners, that the next time you go to Kirchberg in Luxembourg and you pass next to ECJ, you'll be already thinking, I know what they do. I know how many. And at least a little bit of that discussion, of course, not enough. So if you want to know more, we'll share some links in the show notes as well. And what remains is to thank you, Takis, very much for today.
It was my pleasure. Thank you very much for having me.
And this is it for today. Don't forget to subscribe, to follow us, to check what we're writing on all the social media. And of course, don't forget to suggest guests as well, maybe based in Luxembourg, all over Europe. I'm always open to new ideas. This was Silux, and my name is Hanna Siemaszko.